Hello, GPAR. Welcome to this morning's coffee talk. We're so happy to see a lot of folks in here and be with us on this Thursday morning as we talk about rental issues that are popping up and we're dealing with around the city of Philadelphia. We're so lucky to have our guest with us this morning. But before we get to that, I just want to let everybody know we'll be soon pushing out to our members information about a Phillies night out at the ballpark. Our YPN committee has been working really hard to come up with a cool event for next month, and we would love to see a whole lot of people there. We have a limited number of tickets. There's also a tailgate portion of the event that is also optional, but keep an eye on your inbox. We'd love to see a nice, strong turnout, just like we did last year. And kudos to the YPN committee for all the work that they've done in arranging for that great event. Nothing like fun night at the ballpark in the summertime. And look, the Phils are looking for a sweep tonight. So with that,
can we just go to the tailgate and not the game?
Whatever you like,
some of these games are brutal.
They won the last two.
Yeah, I know.
Won the last two. We'll take that. So with that, let's welcome our President Annette Collier. Good morning, Annette.
Good morning. I am so excited about Paul Cohen talking to us today. He's doing a great job for the rental market and the protections thereof. So, Paul, thank you again. I know that you were at an event that several of us were at last week at HAPCO, and just want to thank you for your presentation there. And we're delighted to have you this morning. So thank you.
Great. Thank you, Annette, and thanks everyone for joining this morning. I first want to get started by telling you some good news. So normally I do these talks and it's all bad news. City of Philadelphia is not it's not a place which is very favorable to landlords. In fact, it's very unfavorable to landlords. And I'm usually talking about all the bad things that are happening in the city of Philadelphia that we're trying to stop. Lots of which we do stop, but some of which we do not stop. And that's what I have to tell you about what's coming. But today, what I wanted to do is just at least start with some good news for a change. So the first thing I wanted to mention is that the mayor, I'm sure most of you have seen, is asking for an $800 million bond to be able to do a lot of things for affordable housing. I'm a little concerned about the fact that it's an $800 million that she's asking for the city to borrow. That is very concerning because that money is coming out of the general fund, meaning that the bond is secured by the general fund. A lot of times when the city issues a bond or the state issues a bond, they have a specific tax that goes along with the bond so that the tax pays for the bond. So it's guaranteed by the tax and the tax pays for it. Good example of that is when Mayor Kennedy asked for the bond for pre-K schooling. As part of that funding, it was going to be funded by or secured by the tax on sugary drinks. This, however, is not one of those situations. This is an $800 million bond that's going to be paid for by from the general fund. So that means about $60 million a year in debt service is going to have to be paid to pay back that bond. So that's very concerning. I did say I was going to start with good news. So I'm going to get to the good news of that. That's just an aside so that you understand where the money's coming from. We're going to have to pay that back to the city of Philadelphia. I'm not really in favor of borrowing money that you don't have, but that's a separate story for another day. The good news is that some of that money is going to flow for landlords. About 17 million of that, hopefully, will be appropriated. None of this has gotten approved yet. Will be appropriated for security deposit payments and possibly application fees. So the money hasn't been appropriated. The rules aren't in place, and where the money is going to be spent isn't in place yet, but this is what we're hoping for, which would be great news for landlords, especially in light of the fact that some of the new bills that are being introduced that are most likely going to get passed, which I'm going to talk about in a minute, do affect security deposits. But Suffice it to say that if we get $17 million, that will help tenants pay the initial security deposit, that will help tremendously for them to be able to rent your properties and for you to be able to actually collect the security deposits up front, be able to get full security deposits, possibly 2 months in security, and be able to rent to the tenants. The other thing I wanted to mention is that there is tenant financial assistance. I don't know how many of you are familiar with that, but if you have a tenant that is delinquent in the rent, before you can file a landlord and tenant case, you first have to file with diversion. Okay, hopefully most of you are familiar with that. Actually, hopefully most of you are not familiar with it, that you don't have to file evictions or haven't had to file an eviction case. But if you do, you first have to go and file for diversion. And this is very important. Along with filing for diversion, you have the potential to get financial assistance for the tenant. The financial assistance that you can get is up to $3,500 for the back money that is owed, plus an additional 2 months of ongoing rent. Now, here's what's really important for you to know. If it goes over to $3,500 in back rent, the tenant does not qualify for financial assistance. So, what I try and explain to everybody, and this is really important, especially for your smaller landlords that aren't familiar with the process, if a tenant's rent is over $1,750 a month and they haven't paid for 2 months, you're going to be over that $3,500 limit. So while you probably don't want to file on tenants in the first month, although I do recommend that most landlords do, but your smaller landlords generally don't. They try and work with their tenants and not file against them. In this situation, it's real important because it actually helps the tenant by filing within that first month of delinquency so that you can get the tenant financial assistance. If you wait to that second month and it goes over to $3,500, tenant's not going to qualify for the financial assistance. So filing with diversion is not an eviction filing. It's not a landlord-tenant complaint. It's a pre-eviction filing. It doesn't go against the tenant's record, and it allows them to get the assistance so that they can get caught up in the back rent. So very helpful. It's something that's great that, and this is a city program, it dovetailed on the federal assistance from COVID, but now this is a city program. It's city money that's been appropriated. Great program that allows the tenants to get that financial assistance, but you got to file before the rent gets over $3,500 a month. Very, very important. One of the new changes that just came about with financial assistance is that if the money that they owe is over $3,500, they used to be automatically disqualified. But now, if it goes over $3,500, you can waive the difference. So let's say it's $3,550. Before, they would just automatically not qualify. You can now waive that $50 so that you can get the $3,500 plus the 2 ongoing months. Very important. So there's going to be a new form that's coming out for financial assistance. It's going to be rolled out in about a month, where they're combining everything together. In other words, it used to be 2 separate filings that you had to do. You had to apply for diversion and separately for financial assistance. Now it's all going to be done with one form, and there's going to be a checkbox on there that you can waive that $50. It's not very intuitive. The checkbox doesn't say, here's a checkbox that you check this off and waive the money, but it's going to be there. Look for it. And if you have a problem with it, we can help you out with filling out the form. But that's really important so that you can get that financial assistance. So that's a great thing, and that should help tremendously with collections of delinquent rent. Of course, there's still the problem if the tenant doesn't pay, you have to wait 60 days to be able to file for an eviction. So if you get the financial assistance, you get the assistance for an additional 2 months of ongoing rent. After you've gotten that last payment, if the tenant stops paying, you have to wait 60 days before you can file for an eviction. Okay. It's not totally bad because you don't have to go back to diversion, which is a 30-day delay. So you're really only losing 30 days on the back end. But at least you're getting, in theory, 3 or 4 months of rent paid. So it's a great program. It's definitely a positive. It's something that's good. It's one of the good things that's happening in the city of Philadelphia. Another thing I just want to mention is that Rents are going up, so they are increasing, which is great for landlords. Don't know how long that's going to continue, but hopefully that will be the situation going forward. I try and tell legislators that all these laws that they keep passing, it's just not good for landlords, and you're forcing you being city council is forcing landlords to want to sell their properties and get out of the city of Philadelphia. So the more that they can do to help landlords, the better off we're going to be. And the other thing I try to say to them all the time is just once, I say, just one time, can you pass a bill that goes after the bad tenant? Just once. I just like to see you just come up with one bill. Like every single bill is going after landlords. Like, come on, you got to go at some point, and you got to say at some point, we got to go after the bad tenant. It's not just all about the bad landlord. And I also try to explain to everybody that we are the biggest advocates for tenants. Landlords are the number one advocates for tenants. They're our customers. We love tenants. Without tenants, we're out of business as landlords, right? We love them. Okay. What we don't like is bad tenants. Bad tenants are a problem. And they're not only a problem for the landlord. You know, you have a 10-unit building, you got a bad tenant in there. They're a problem for all the other tenants in that building as well. And when the tenant's not paying and you're suffering, guess what? You have no choice. It's a business. You got to raise everybody else's rent to cover that. So bad tenants are bad for the good tenants as well. Okay. So at some point in time, I keep pushing for it. I'm not just like one time like to see a law that goes after the bad tenants. But I'm still holding out hope. But yeah, I would hold my breath on that one. Okay. Some of the recent laws that are out there that are most likely going to get passed, I want to talk to you about so you can prepare for them. The first one is with regard to the security deposits, which I was alluding to before. That bill basically, well, I'll tell you what it's going to say, what it says at the present time. Don't need to confuse you with it. We've been able to talk to the sponsor of the bill, and we've gotten a couple of amendments to the bill, and this is what the final bill is going to most likely look like. Sponsor still has to talk to the rest of the legislature. It has to pass, but this is most likely what's going to happen. So if you collect 1 month in security, you can collect the security up front. Okay. And when I talk about security, people often talk about 3 months of rent that the tenant has to pay. The first month, the security, sometimes they call it the last month's rent, and sometimes it's called 2 months in security. And just so you know, last month's rent in advance, you can call whatever you want. It's considered a security deposit. Okay. So if you have 2 months in security that you're going to ask the tenant to pay, and I want to take out the first month's rent out of the equation here because people keep talking about 3 months rent and it just gets confusing. Everyone knows you got to pay the first month's rent up front. So we're really just talking about the security deposit. Okay. If you want to collect 2 months in security, then the tenant will have the right to pay that security deposit in 4 installments. Okay. So the first month, before they move in, they'll pay a half a month's rent. Then the next month they'll pay a half a month, a half a month, and a half a month. So it'll be over 4 months. It's really over 3 months because the first month you're getting up, the first half you're getting up front. But the security deposit can be paid. Tenant will have the option of paying that in 4 installments. Okay. If you only collect 1 month's rent, then that entire month's rent has to be paid up front. But anything over 1 month. So if you collected 1 month plus an additional $100, and let's say that it was $1,100 was the security deposit, you collected an extra 100, that would make a total of 12. That would be paid if the tenant elects in 4 equal installments. So it'd be $300 each. And Mark, can we get that background music? That'd be awesome. Come on, that'd be great. Sorry, I just saw Mark playing the guitar. I was like, oh, this would be awesome if I could have him in the background while I'm talking. That'd be new and improved. Anyway, sorry. Does that make sense to everybody?
Hey, Paul,
Yes.
we forgot to mention this at the outset. we totally welcome any questions. So if you guys have questions, feel free to unmute yourself. Just be respectful of other people. Try to avoid crosstalk. So you're welcome to go ahead and engage in that way, because Paul said he doesn't like just talking. While he loves listening to himself talk, he doesn't want to listen to himself talk. I'm making fun.
Paul does not like listening to himself talk.
Yeah.
And quite frankly, I love doing these presentations live when you get you get a response. It's just so hard talking to a computer screen.
Yeah.
Yeah.
So chime in, folks. And then another thing I would like to just drop on in is Lexi McDowell from our team. She's our government affairs director, has been working very hard on this legislation that Paul has mentioned. Our government affairs committee took a position against this legislation. From there, we went ahead, we offered up all city council members that are on the committee that is hearing this bill. We offered up a position paper to explain why we're against it and the issues that are challenging to us. And then they had the committee hearing, and President Annette went on behalf of GPAR to testify. So she entered in written testimony. She had our position paper entered into the record. And unfortunately, she wasn't accommodated with a nice amount of time to talk, but Annette rolled with it, got the main points out, but she was there testifying on behalf of the association. So as Paul is talking about this, it's important for you guys to kind of understand how GPAR is involved with this. And we've been working with our partners in the real estate coalition on these bills, including just yesterday afternoon, there was a 4:30 meeting with the council member to discuss where things are at with that process. So thank you very much, Paul.
Yeah, just to expound on that point, Lexi's done an unbelievable job. GPAR is doing a great job, and that's doing a great job, and so is Matt. Matt's also doing a wonderful job. It's all behind the scenes things, and people ask me all the time, what do different organizations do and how do they help? And 90% of the stuff that is done, you won't see. You won't see all the bills that GPAR is helping to kill that never see the light of day. You don't hear about those. All you hear about is the bad things that are happening. And I can tell you that GPAR is at the table all the time in all of those talks and is helping to reshape all those bills in a good way or a better way. I won't say in a good way because at the end of the day, it's not good legislation. But it would be a lot worse if GPAR wasn't there. And one of the huge amendments that GPAR helped to get through was that the bill originally said that all security deposits, no matter how much, would be paid over 4 installments. So having it just be for 1 month, security deposits that are over 1 month is huge. And hopefully, as you all know, after 1 year, you can't have more than 1 month in security anyway. So a lot of landlords only take 1 month in security. However, unfortunately,
I have a question.
sure.
You mentioned, we all know about these changes, and we also realize that, from the information that I got from HAPCO is that over 1,000 landlords executed or left the city of Philadelphia. Some went and purchased in the counties. With these type of legislations, and if they continue, is it the possibility that there will be less and less small landlords who, in my opinion, tend to be more compassionate, to tenants when they are truthful? We are able to guide them to some of the assistance programs that you talked about. But then there are some people that, it is what it is, right? They're not going to pay. That's one of my questions. And then the second question I have is, has there been any conversation about tenants having to go through housing counseling before they become a tenant?
So in answer to your second question first, counseling before they become a tenant is talked about periodically, but there's no funding for it. So a lot of programs, just about all the programs, require money. So in order to be able to do that, there would have to be some funding source to be able to pay for that. Right now, funding is at a premium, especially with the new administration in Washington cutting funding to the cities, states, and different federal agencies and nonprofit organizations. So for
It,
that to happen would be a difficult thing. One of the things that Alan Dom was pushing for is financial literacy in schools, which would be huge. That would be a great thing if we could get that in the school system as a course. That, you know, you actually take financial literacy to understand financial counseling. Basically, is what it would come down to. So that would be
I'm
very
glad
helpful.
you mentioned it. So, do you know whether or not there's a conversation regarding the budget for that? And the reason being is that the average person, that I run across in the city of Philadelphia, they do not know about budgeting. Nothing is ever going to work for any of us if we don't have a plan, right? And
No,
so,
you're
unfortunately,
100%.
not everybody's been exposed to that concept.
No, you're absolutely correct. And one of the things that happens in diversion is that a housing counselor is assigned to the various tenants. The problem is that we don't have enough housing counselors for every single eviction filing, and there isn't enough mediators for every case to go to mediation. It's one of my um, gripes, concerns, complaints about the program is that it was initially set up to allow the tenant to get financial assistance. And that was back when we had financial assistance with the moratoriums that existed from the federal government, and the federal government was giving money for financial assistance. Okay. The idea was to give a 30-day pause so that the tenants could get financial assistance. They would have a mediator um, hear the case, and a housing counselor was assigned to the tenant that could do exactly what you just referred to, which would be to give them the financial counseling. So that the idea being is if you're going to get the financial assistance one time, it's not going to help you if you don't have your finances in order going forward. So if we're going to give you this money, we want to know that going forward, you're going to be able to manage your money so that you can keep paying your rent and then on an ongoing basis. So that is very important. So we don't even have enough housing counselors for the existing cases, let alone to have it for everybody before they become a tenant. But yeah, that'd be a wonderful thing if we could find some way to make that happen. In answer to your other question is yes, a lot of landlords are leaving the city of Philadelphia. It's become more and more difficult to run your business as a landlord in the city of Philadelphia. And with every piece of legislation that comes down, there's another landmine that's out there, and a trap for you as a landlord that if you get caught up in it, you're not going to be able to get your rent paid. Some of these things require that you pay back the rent, and I'm going to go through those shortly. So yeah, it's a very difficult climate. The word I use in the city of Philadelphia is it's very challenging to be a landlord in the city of Philadelphia. And one of the things I tell all of city council is that if I was to give you $1 million and I said, here's $1 million, you have a choice. You could invest that $1 million in rental property in the city of Philadelphia, or you could invest that $1 million in rental property anywhere in the state of Pennsylvania outside the city of Philadelphia. Where would you invest that money? And it's great to a person. They all just look at me, silence, because we all know the answer to that question, but they can't admit that. But that just sums it up to me. It tells you exactly where we're at in the city of Philadelphia. Now, what happens is a lot of small landlords, especially that have like one or two units, they might have had a parent that died. They can't sell the property and they decide, hey, you know what? I can make some money. I'll rent it out. Okay. That person has no idea from day one what they need to do to be a landlord and what it takes to be a landlord in the city of Philadelphia. Okay. I actually, there you go. It's a book I wrote. You can see how thick it is. This is a book that has all the laws in the city of Philadelphia that you need to comply with as a landlord. Okay? It's 2 inches thick. That's what you need to know as a landlord to be able to properly handle rentals in the city of Philadelphia. There are so many rules and regulations and traps that it makes it so hard to comply with everything that needs to be done. You think, oh, you know what? I got this property on here. I'll just rent it out. No, it's not that easy. Okay. The other thing I try to tell city council, and I tried to do this, by the way, I sold all my properties in the city of Philadelphia, and I invested elsewhere because it just doesn't make sense. At least it didn't for me. Okay. And when I had one last Section 8 property, it was all paid off. I was making a couple of dollars with it. I said to city council, I said, here's what I'll do. I'll give you the profits from this property. I'll assign you all the profits. What I want you to do is go through the process as a new landlord, figuring out everything that you need to do to be a landlord and comply with all the law. So go get all your licenses, go get your um, commercial license, your housing license, your lead paint, like go through all those things that you have to do. I said, and don't go through the back door. Don't go through the back door at L&I. Go through it as if you're just an ordinary citizen having to do all these things, and you try and figure that out. And I said, you can have all the profits. And I know you can't take it as a council person. So I said, whatever charity you want to donate it to, I'll give all the profits from the property to that charity. I just want you to go through it and see what not one of them took me up on that offer. Okay. What I'm trying to do now is get someone in the press to do it. I think it would be a great, the problem is I sold that property, but I'll go buy another one just to prove a point and let them go through the process and write about it and show like, this is all the things that we need to do. It's a nightmare. All right. Anyway, I get a little off track, but I did want to answer your question. Getting back to legislation. Okay. So I talked to you about the one bill that's most likely going to get passed with the security deposit. The second one has to do with application fees. They want to limit the amount that you can charge in an application fee. It was originally $20. They're doing us a huge favor by increasing that to $30. That is absolutely ridiculous that you can only charge $30 for an application fee. So when the tenant comes to apply for your apartment and you have to do a screening on them, you can only charge $30 for that screening. Okay. Your charge is a lot more than that. One of the huge arguments that we've had with them, and when I say we, a lot of that is with GPAR, is always at the table for all these different conversations. The point that we had was that if you're going to properly screen somebody, it's not just screening you have to do anymore. You're now screening for background, criminal background. You're screening for fraud, which is huge. I don't know how many of you have experienced that yet, but if you haven't, you have a decent amount of properties, you will. Okay, there is so much fraud out there in rental applications and people moving into apartments. There's now a whole cottage industry for screening just for fraud. Okay, that's expensive. You're not doing that for $30. You know, you can maybe get a credit check within the $30 charge and do a little bit of screening. Okay, but here's the kicker. They passed something called the Renters Access Act. I don't know if you're all familiar with that. Okay. Under the Renters Access Act, you cannot just screen based and turn somebody down just based on a credit score. It's illegal. If you turn someone down solely because of their credit score, they can take you to fair housing and they can sue you. Okay. So if you can't just do a credit report and you're supposed to do a holistic screening, how are you supposed to do that for $30? Like the two bills don't coincide with each other. You can't have both. Okay. If you want to just allow us to charge the $30 and you want to force us to just do a 10 screening, then we should be able to use that screening report, the credit report. But you're not allowing us to do that. Okay. And that kind of dovetails into, I just wanted to quickly explain the Renters Access Act for those of you that aren't familiar with it. Okay. You have to do an I love this term, an individual assessment, this sentence, an individual assessment based on uniform screening criteria. Think about that. Individual assessment, but uniform criteria. It's an oxymoron, right? If I have uniform criteria, I have to apply it uniformly, or you're going to sue me as a fair housing violation, discrimination. You can say you discriminated against me. But they want you to have uniform criteria. Look at it on an individualized basis. Okay. Since the law's been passed, I've been scratching my head, still scratching my head over how to do that. And I've been asking them about that, and it just makes absolutely no sense to me. Okay. But that's what's required. So I can tell you what you need to do to comply. And this is very important because when the law was originally passed, nobody really understood it. And I think people still don't really understand it, but they're starting to enforce it. So it's real important that you put together screening criteria. That's the most important thing. You need uniform screening criteria that you need to, this is a requirement under the law, that you need to present to the tenant before they rent the apartment. Okay. And by the way, how's a person that just inherited the property from the parent that died going to have any clue that that exists and they need to put that together? And how they're going to get that together quickly to have uniform screening criteria. Okay. But that's what the law requires in Philadelphia. Okay. So you guys that have been doing this, I'm hoping you already have some type of uniform screening criteria. If you don't, you need to put together a plan for that uniform, a written document that has your uniform screening criteria. This is how I'm going to screen all my tenants. And that has to be presented to the tenant up front so that they know what they need to do to qualify for the apartment.
Hey, Paul, we got a couple of questions, and Millie and Annette, I'll go to you after I just pull out a couple of quick ones.
Okay.
Um, is there a best practices checklist for the uniform criteria?
It's actually more of a negative, meaning like a negative checklist, like things you can't do. Okay. So things you can't do is you can't just screen for a credit score. If you just use the credit score, then that's a problem. Okay. You can't look at if the person, let's say, was delinquent during COVID times, COVID period, you can't consider that when you're looking at whether or not you're going to accept the tenant.
I guess the question here is there an easy to use like tool or something so you kind of know it's like all kind of like laid out to help inform so that someone isn't inadvertently like doing the wrong thing on this.
Yeah. So what I'll say to you is that if you use, and I don't like to plug any companies, but there's certain screening companies you should check with whoever you're doing the screening through, to give you that, because that will then coincide with what you're actually doing. So the screening companies have that. I could give you, like samples, but it's not going to really help you if your screening company isn't following through on
Right.
those examples. So talk to a screening company, ask them if they're familiar with the Renters Access Act. Everything's acronyms nowadays, so you say RAA. Okay. If they're familiar with that act, and then if they are in compliance with it, because they're not required to comply with the act, you are. So if they just do the screening, they're not familiar with what the act requires. They're just going to give you the screening that you asked them to do. You now have to apply the act to it. So the best thing to do, and my recommendation is to talk to your screening company, make sure they know how to comply with the act, and they can give you the written criteria that they're going to be using in the screening, and then you can give that to the tenant, and that would be the plan.
All right, so we got some folks on deck. I got another question I'm just going to pull out real quick.
Sure.
So the bills that are under consideration that came from Council Member Rue Landau,
Yes.
if they were to be enacted, what's the effective date for those two pieces of legislation?
So the security deposit one, I don't think is that bad, because you can still take 1 month in security. It's bad for landlords that are used to taking 2 months in security. The problem that Representative Council Member Landau had was that a lot of landlords, according to her, I think it's a very small subset, but according to her, a lot of landlords don't return to 1 month in security after the first year when they have 2 months. And
But when
that's
would they take effect though, Paul? Like if they get if they go to the mayor's desk and she signs it, when do they take it?
60 days.
Okay, 60 days.
Yeah.
All right, guys. So that hasn't even been voted out of committee yet. So there's
No.
still some steps left in this process. Millie, let's go to Millie. Millie's got her hand up. She wants to ask a question. Go ahead, Millie. Welcome.
Yes, thank you. I see someone else asked the same question. If they have an eviction, can that be a basis for not moving forward with a potential tenant? And I call previous landlords for a reference. Can that also be used, or is that part of the no-no?
So that's a great question. It's a little complicated for right now. It's complicated because what's going to come, which I'll tell you in a minute. So for right now, if there was an eviction, just an eviction, but not a judgment, like the tenant didn't lose in court, you can't consider it.
Let's say they lost.
Okay. Then the next question is, if was the judgment vacated or satisfied? In other words, did the tenant, let's say there was a judgment against the tenant for $3,000. Did they pay the $3,000? If they did, you can't consider it.
Okay.
And if the judgment is more than 4 years old, you can't consider it.
Oh, okay.
All right. Also, if there's a judgment by agreement that's currently in place, you can't consider it. So the hope would be that your screening company knows about all these exclusions and they exclude them out when they give you the credit report, as opposed to them just telling you there's the judgment and you are now having to go figure out whether or not you need to exclude it. That
So
becomes a nightmare for you. So you want to use a screening company that understands these things and properly excludes them from your consideration.
yes, so I am the screening company.
Oh, okay.
I
All
go
right.
on the municipal court site and I
Okay.
look up, all the different categories like noise.
Okay. Yeah, here's my suggestion to you. Look up the Renters Access Act. It has all the different exclusions.
Okay, great.
And then what you want to do is put those institute those exclusions into the report that you give to the landlords. And then you can start advertising that you're one of the screening companies that complies with the Renters Access Act.
Oh,
which
sorry,
will be,
what purpose?
which will be huge for your business.
Like if I wanted to, what? Sorry, repeat.
I'm
Uh-huh.
saying for your business, I would suggest that you advertise that you comply with the Renters Access Act
Oh, okay.
instead of landlords having to do that on their own. That's a nightmare.
Okay, got it.
So the screening company just gives them the information because that's all the screening company is legally obligated to do. You, as
Mhm.
the landlord, are required to comply. So if you just get the raw data, now you have to apply it. That's hard. If the
Right.
screening company knows what they're doing and they go through and they do that for you, that'd be awesome. So if you're
Okay.
able to do that, I think that would help with your business, and then you can advertise that you comply with the Renters Access Act.
Oh, okay. Great. Thanks.
You're welcome. Any other questions on that?
Yeah, Glenn, go ahead, Glenn. Good morning. Welcome.
Good morning. Thank you. This is pretty frightening, you know. I'm new to the area, bought a lot last year to build an apartment building, and now I knew it was bad, but I didn't think it was just going to keep getting worse and worse. But my direct question is, the book that you mentioned, Paul, do you make that available? Like, is it for sale? Is it available to the public, or do you solely use it in your practice? And if so, how do we get in contact with you? Can you put your information in the chat?
So if you go to the HAPCO website,
Mhm.
also general counsel for HAPCO, HAPCO,
Okay.
Homeowners Association of Philadelphia County. On their website is a book that has, so I took my book and incorporated that into the HAPCO book. So HAPCO now has all the different laws and regulations and forms. It's a great book, not because I wrote it, but it's a great book that goes through everything. So that
Okay.
would be
That's perfect. Yeah, I'm familiar with Apple. Thank you.
Okay.
Thanks, Glenn. Christy, I see your hand up. Welcome. Good morning.
Hi, how are you? Thank you. Hey, Paul, how are you?
I'm doing great.
Good. I've got a quick question for you. Two quick questions. One about the security deposit. So we utilize the Sure Deposit program, as you know, and I'm wondering if any consideration was given to that type of bond program when the discussion of that security deposit bill was being had and whether or not that will have any impact.
No, it doesn't have any impact on that. That's fine.
Okay, excellent.
Because the tenant's not paying that over time. The idea was to help tenants that can't come up with 3 months of rent up front.
Okay. Second program is with regards to this Renters Act. So we already have screening criteria or application criteria in place that includes income, employment verification, landlord eviction, criminal background. So are you saying if everything else, if I'm understanding this correctly, if everything else comes back positive, positive landlord, employment status, income qualifications, but they have poor credit, and we have a requirement for good credit in that application criteria that's handed out, we cannot evict them or we cannot deny them, excuse me, just based upon that bad credit?
That's a great question, and that goes into the gray area of nobody's really sure. So
Okay,
it says you can't deny them based on a credit score alone. That's
okay,
the language of the act says. Okay. But you've looked at everything. So what they're asking you to do is say, okay, I've looked at the score, but let me look at everything else too. And if everything else doesn't make you feel comfortable with the score, then you can deny them. But at some point, you have to just look at everything else.
right,
Okay.
understood.
So that's the individual assessment. So you have to just say, okay, let me look at everything else. Is there anything else that's going to make me feel more comfortable with this situation? And if the answer is no, then that's fine. Then you can turn them down. But be advised that the tenant then has a right to dispute it. And they can give you, say, hey, I have additional information that I want to give you as to why you should accept me. So you'll get the additional information, you'll look at it, and then you'll make a decision. But you just have to look at all that additional information. It doesn't say you still can't deny them after you've looked at it.
Right, but we can't discuss their credit, what we saw with them. So what requesting or them offering additional information when you're not allowed to have that conversation, that's a whole nother level of
Yeah,
complexity.
it is, but you still looked at it. So you said, okay,
Right,
I looked at it. I did the individual assessment. I turned them down. That's fine.
okay, okay, thank you.
You'll still get sued, but it's okay. It's everybody sues for everything. It's great.
Clear as mud. Okay,
Yeah,
thank you.
exactly.
Thanks, Christy. And folks, feel free to chime in with any other questions. Just simply raise your hand and we'll get you into the mix. Paul likes the interaction a ton, and some of this interaction has been really good and helpful to the conversation. So please do not hesitate. This is your conversation as much as it is Paul's presentation.
Yeah,
So
no,
go ahead, Paul.
I'm more interested in answering your questions and helping you out. I could yak all day, but if it's not helping you, then it's useless. So I really want to help you and answer your questions. One thing I did want to quick mention, however, which is really important, is that if you're managing your own property, not a problem. You can go ahead and manage your own property. If you're managing property for others, then that has to be managed through a broker, has to be managing the property. So either the owner's managing the property or the broker's managing the property. Okay. As far as leasing properties, anyone that's leasing a property has to either be the owner or a licensed salesperson. Okay. Individuals can't lease properties that aren't licensed. All right. Very important. Hopefully you're all aware of that, being members of GPAR. But here's the point I want to make to you all is that the broker needs to sign the lease agreement, not a sales agent. In Pennsylvania, there's a legal requirement that the broker or the owner signs the lease agreement. A salesperson cannot sign a lease agreement. Very important. All right. I happen to disagree with that law. And I do seminars on that for over an hour. And it comes down to where in the law a comma is placed in the interpretation of it. but the real estate commission has interpreted, and I've talked to them on many occasions, that they believe that the broker has to sign the lease agreement. And if the broker hasn't signed it or the owner signed it, then you're going to be in trouble. And I've dealt with a lot of these cases, and it's one of those low-hanging fruits for the real estate commission, because when they do get a case, all they have to do, and this is the first thing they do, is they subpoena all the leases that you've signed for the last 4 years. And they'll take a look at them, and they look at who's signed it. And if it's not the broker or owner, boom, $1,000 fine plus interest and penalty. And it can be substantial if you have a lot of properties. So real important, make sure the broker or the owner is signing the lease agreements. All right. Any questions on that? I'd say, yeah, we got 2 questions.
Go ahead, Annette.
Yeah, I'm glad that you brought that up because the reason the commission for several years now have had concerns is because there had been agents. I'm not saying that they were the Greater Philadelphia Association of Realtors or any realtors that was doing this, but there were licensed real estate agents that were collecting the money from the landlords and not giving it. And we know that it shouldn't be happening anyway, but those things were happening and they were getting multiple complaints. I also serve as a consultant. So I personally had to go after people to relinquish the money. And in turn, I wound up becoming the property manager. So those kinds of things, unfortunately, whenever there's a bad apple, for us, it only takes one.
Yeah.
And then we all get categorized in one situation. But the other thing is, could you kind of go over what are the required forms that our landlords need to have and brokerages need to have in their files so that when an eviction is about to take place and we have to go through the eviction diversion, we have everything that is necessary so that the eviction is not delayed?
Sure. Okay. So the first thing you need is to have a commercial activity license. Okay. So if you're going to be a landlord, it's considered a business in the city of Philadelphia. So you need a commercial license to be able to have that business. And you need to get a city tax ID number so that you can pay taxes to the city of Philadelphia. That's the very first thing you need to do. Next thing you need to have is the certificate, the housing license. So you need the commercial license, and then separately, you got to get the housing license. Okay. It used to be called the housing inspection license, but as we all know, they don't actually do the inspections of every unit. So they took out the word inspection because an inspection is not performed. It's just a housing license. It takes them 2 seconds to check the computer to see whether or not there's any violations against the property, to see whether or not taxes are owed, and see whether or not it's properly zoned. For that, they charge you, I believe it's $69 now. It's outrageous, but we haven't complained too much about that because if we do, then they're going to want to inspect every unit, and we don't really want them to inspect every unit off the record, right? Although they are talking about passing a bill to require inspection of every unit, separate issue.
Okay.
All right, I digress. Okay, try and keep me on track. Next thing you need is a lead paint certification. So you have to, if your property was built after, before March of 1978, you need to have a lead paint certification. So it has to be tested and it has to be certified. This is really important. You have to give that certification to the tenant before you rent to the tenant. And it's crucial, make sure the tenant signs the certification. Okay. You're going to need to prove if you go to court that the tenant actually received that lead paint certification. You also need a certificate of rental suitability. Okay. Certificate of rental suitability is good for 60 days. So within 60 days of you renting that apartment, you have to apply for a certificate of rental suitability. The law says that you have to give the tenant a copy of the certificate. It does not require that the tenant signs it. I will tell you that you should make it a requirement that the tenant signs the certificate, because when you go into court, you're going to have to prove that the tenant actually received it. Best way to prove that the tenant received it is that they signed off on it. If they haven't signed it, the judge is going to say, Mr. Tenant or Miss Tenant, you didn't receive that certificate of rental suitability, did you? Judge doesn't say, did you? Right? They ask the leading question, and the tenant says, no, I never got it. And you just lost the case. Okay? Big problem. Okay? I do want to tell you that if you don't have that certificate of rental suitability, you cannot collect the rent. Okay? However, if the tenant has paid you, you do not have to refund the money. So if the tenant paid you and the tenant figures out, hey, you don't have a certificate of rental suitability, I'm going to stop paying you. They don't have to continue to pay you, but whatever money they've already paid, they don't get back. And there's a court case on that. Okay? Which is good. Just as an aside, Council Member O'Neill just introduced the bill that we're fighting that says that if the person doesn't have it, if you don't have the certificate of rental suitability or the license, you have to notify the tenant that you don't have that. And in that notification, it says, and by the way, Mr. Tenant, you don't have to pay the rent. It's crazy. So yeah, I just had a conversation on that yesterday with the council president's office. So we're trying to get that one stopped, and GPAR is working along with us on that. That's outrageous. But just so you know, you have to have that certificate of rental suitability and make sure it's signed. Okay. With regard to the lead paint certification, if you don't have that, not only doesn't the tenant have to pay the rent, the tenant can claw back all the money they've already paid you. So if you didn't give them that lead paint certification at the beginning of the lease and they paid you for a year and now they figure that out, they can sue you to get all that money back that they paid you for the year. Okay. So the lead paint certification is crucial that you get that signed by the tenant. You get it and signed. Right.
Hey, Paul, we got a couple of other hands up here.
Yeah.
George, let's go to you.
Excuse me, can I interrupt just for a second?
Sure.
Paul, isn't the bed bugs also a form that's needed?
Yep,
Or
I'm getting
that's
there.
not?
I'm getting there. Sorry, I keep digressing, but I'm getting to all the forms. Yes.
Okay.
So
George,
while we're
and
talking
then
about
Jack,
yes,
you're
there
on
is.
deck.
Yes, there's a bed bug form, and you also have to give a brochure. So there's 3 brochures that have to be given: Partners in Good Housing, a lead paint pamphlet, and the bed bug brochure. So make sure you give all those brochures to the tenant as well. Then I'll get through the rest of the stuff that you need, but we can answer the question first.
Okay, thank you, Matt. Paul, great to see you again.
Always a pleasure.
Most of these, apart from the broker having to sign the leases, came from the real estate commission, I assume. Most or all of what you're talking about, apart from that, are all applicable to only our county, as opposed to maybe that credit score issue.
Most of the laws I'm talking about apply only to Philadelphia. I would have to go through each one individually to tell you which ones are state and which ones are national.
Okay, thank you.
All right, George, you got your hand up. Thanks for your patience. Fire away. George, going once, going twice. All right, Paul, we're back to you.
Okay. You need a high-rise license. If you have a high-rise, you need a facade inspection done, depending on how tall your building is. And this is my favorite one. If you have parking on the property, you may, depending on the type of parking, I'll tell you that in a second, need a parking license. So if you have parking that anybody can use, it's not assigned to any particular tenant, you're not charging them for the parking, just open to all the tenants in the public, no problem. You can just have that. You don't need a parking license. If, however, you're charging for the parking and you say to the tenants, we have parking available, it's an extra $200 a month for the parking for a parking space, and you get an assigned parking spot, even if it's not assigned, but you get a parking spot and you have a sticker, then you have to get a parking license and you have to pay the parking tax of the low rate of 22.5% as a tax. But that's outrageous. That's the parking tax. I never heard of such a high tax anywhere, but that's what it is in the city of Philadelphia. So if you have a parking lot that you're renting out or you're charging people to park there, you need a parking license. Most people are not aware of that. And I can tell you about
Hello,
4
can you hear
years
me?
ago now, I guess pre-COVID, times are all messed up with COVID. It's probably 5 years ago, that the city was going around in a helicopter and finding all the different parking lots that existed. And we're sending notices to all the people that had the parking lots that they need to start paying the parking tax as well as getting a parking license.
Eileen Gray, you got a question?
Yes.
Welcome.
Hi, Paul. I just wanted to ask you, landlords that we represent ask us to put in the summary in the MLS a minimum credit requirement to rent their property. Is that no longer legal?
It's it's a little tricky. You can't just exclude them if they don't get to that credit score. You still have to look at everything else. So
Okay.
the best example I can give you is that if you've ever applied to Harvard, which I'm sure all of you have, when you went to apply, they said, hey, you need a 740 on your SATs, right? Or whatever that number is. But, when you go to the interview, they say, yeah, you can still, if you have less than that, you can apply and we'll take a look at it. But we all know you have no shot in hell of getting in, right? Unless you're a football player, basketball player, I mean, you got something else going on. You ain't getting in unless you got that credit score. But they still actually look at it. So you have to figure out how to word that so it's the same thing. So yes, you need the 740 score, but we're going to look at you. Yes, you need a certain credit score, but if you don't have that, we're still going to consider it on an individual basis.
Got it. Thank you very much.
You're welcome.
All right, George, we'll go right back to you.
Can you hear me?
Yeah, we can hear you. Go for it.
Great. This is a problem I hope we all have at some point. Paul, if we have overqualified, an abundance of overqualified people, say you have a really nice rental, you have 5 applicants, they're all qualified, which I know is a good problem, but giving them back the criteria that we want to project them for, how do we do that without just simply saying we had a more qualified applicant? Well, even if it's just income, say 5 people make $100,000, the 6th one makes 150, and they all have similar scores. How would you explain that to the 5 that got rejected and not be discriminating or doing anything of that nature?
Yeah, it's a tricky one to navigate. So the first thing I would do is give them their application fees back.
Okay.
Right. And then second, you just tell them that you rendered it to somebody else. This is one of those situations where the less said, the better.
Gotcha.
The more you say can get you in trouble. Because if you say the wrong thing, now you have a problem. So you want to keep it short, simple, and give them the money back. We've rented it to somebody else. Unfortunately, this person had applied beforehand or whatever, and they got approved first, and we rented it to them. I will say this though, that if there's that much demand, your rent's probably too low, but that's a simple business decision. And that'll solve your problem too.
Right. Thank you, Paul.
All right.
Thank you, George. Anyone else have some questions? Feel free to raise your hand, guys. Go ahead, Paul.
Oh, you're back to me?
Yeah.
Yeah, I say it's 10 o'clock. I mean, I could go on all day. I don't want to bore everybody. Is there, if there's no more questions, we can sort of cut it off here, because if I start bringing up more topics, it's going to bring up more questions, and I don't know how long you want to go.
All right. Well, look, this is your platform, and why don't we just do this? What are some things that give us 5 more minutes? What are a few things that you would like to close out on that maybe you didn't get into with us today that might not open up a Pandora's box?
Yeah, I got lots of them, but I'll try and close with this one, and it probably will open a Pandora's box, but I'll try and not try and make it as small a box as possible. How's that? Fair housing. Okay. I'm going to try and boil it down to very simple terms. Don't discriminate against anybody for anything. Okay. We've all taken fair housing classes. By the way, I'm also a real estate broker. So, go through all those classes as well. Okay. And they go through is fair housing, and they'll teach you about protected classes, and I actually teach a lot of fair housing courses. Okay. But if you get hung up on the protected classes, you're going to miss it, because there's a lot of other elements of fair housing that get involved, that you can sort of sue anybody based on anything, because we're all in a protected class, just for the simple fact that we're either male or female or other, like whatever. That's a protected class, sex, right? So you can sort of bring it all down to some way that you're in a protected class, with the bottom line being is, and this is what I try and teach everyone, is forget about all that they teach in fair housing as far as protected classes and learning about all that stuff. Don't discriminate against anybody for anything, and you won't have a problem. Okay, it's a real simple lesson. The other thing that's very, very, very important is that do not have any absolutes. So when someone calls you and they say, I need a reserved parking spot, can I get a reserved parking spot? And you say, yeah, we don't offer reserved parking spots. Problem. Okay. We start talking about emotional support animals and all the rest of the things. There's a million of them that people will say, do you allow us to do whatever? There's a lot of testers that are out there that are trying to trap you into finding out whether or not you say that. So if you say, I absolutely do not accept the Section 8 tenant, sorry, I don't qualify for program, we don't accept Section 8, you're going to get sued. Okay? Do not have any absolutes. Okay? Someone comes in and says, do you accept Section 8 tenant? Apply, we'll take a look at it. Even if you don't, okay? Although you're still required to, and we can talk about that for an hour. The bottom line is, if you just say no, you're going to get sued. They're recording it, and it's going to be a problem for you. And when I say
Oh.
they're recording, we all know recordings are illegal. They're writing it down, what you say in your answers. And I'm going to get that case in court. And here it is. The person said, no, we do not accept Section 8 tenants. So do not have any absolutes, and you'll get yourselves over 99% of the fair housing problems. Don't accept that. Don't have any absolutes, and do not discriminate against anybody based on anything. And that'll get you through most of the fair housing issues. And I could spend, like I said, hours going through fair housing issues, but that's the main takeaway for everybody.
All right, so we'll close out with this. Millie's got her hand up. Millie, you're the last one. Fire away.
I think I know the answer to this. So we tend to rent Section 8 and generally don't do open market. So I guess I can't say either that we mostly rent Section 8, because that's discriminatory.
Yeah, you rent to anybody that qualifies.
Okay.
Okay, then just on that Section 8 topic, real quick, source of income is a protected class in Philadelphia. So because it's a protected class, you can't deny someone based on their source of income or the fact that they receive Section 8 assistance. There was just a law that was recently passed through City Council. It didn't really change the current law. What it did is it added penalties. People think that now the law is just like recently changed to require you to take Section 8 tenants. It wasn't. That's been the law. It just wasn't enforced. But with this new law, it's now being enforced in a big way. And I can tell you, Section 8's gotten a lot better. Like the rents that they give you are at market rate, and some of them are even above market rate. So having a Section 8 tenant is not a terrible thing like it used to be. There's still like requirements that you have to comply with, and there's still other issues that are involved in it. But you are obligated to take Section 8 tenants if the person qualifies. So don't just say I'm turning them down.
Well, Paul, just quick question on that. Do you have to, on the Section 8, what if the owner of the property has not, they're renting out the property, but they haven't gone through the Section 8 process? Like they're
Yeah.
not approved to take Section 8. Is
Yeah,
that
no.
fair to say that the owner's not yet approved? for section
Yes,
8?
and
Okay.
we were doing that for years, and that was the simple workaround. Is we're not approved. Section 8 hasn't approved us for the program.
Right.
That's no longer a valid excuse. So now you have to go through the process. But what's nice is that if someone comes to you and you don't have the absolute saying, no, we don't accept it, you say, hey, apply and we'll see if we can get qualified. Well, it's going to take a while till you get qualified. The person's not
Right.
going to wait around. They'll find something else.
Okay. Thank you.
You're welcome.
All right. Great questions from everybody. I'm sure we could probably go on for another hour or so easily. Maybe we should have Paul back. Annette, do you have any final things to say before we wrap this up?
All I can say is hooray, Paul. I'm happy to know that you're a broker. I didn't know that part. And your presentation is just excellent. The information is great. And all of what you said, because we do a lot of property management, I really encourage your investor clients who are thinking about buying that, you provide these notes to them, because you can get jammed up and you can lose a lot of money. So thank you so much. It was very valuable.
Yeah, thank you for having me. It was great seeing the people that had their video on. Wish I could have done it in person so I could actually see everybody. But maybe
Your
someday.
wish may come true. Your wish may come true one day, Paul.
All right. Sounds good.
I gotta talk to the CEO.
All right.
All right. There we go. All right, everybody. Have a wonderful day. Thank you, Paul. Thank you, Annette. Thank you to all your great questions that you guys threw in. Take care. We'll see you soon.
All right. Take care. Have a great day.